Court of May I please, my lord?
Yes.
My lord, with my lord's permission, may I mention a fresh PIL? My lord, this petition concerns the high security registration number plates. Now, earlier there was bids invited for this process, but recently the cabinet has decided to do away with the bids completely, and there would be therefore no quality control. In fact, the other matters which pertain to the tender issue are pending tomorrow. But what the situation is now, that there won't be any bids, and the parties would be selected randomly for issuance of all these number plates, and which is, my lord, is contrary to two judgments of the Honorable Supreme Court.
Have you filed it?
We have filed it, my lords. All defects would be cured today itself. But the other matters are listed tomorrow where the government is going to take a stand. My humble request was, my lord, if it can be taken up tomorrow or at the earliest possible.
Plate matters. We had heard it.
इसमें क्या है?
He wants it to be tagged along.
This would be normal course come. When it will come?
My lords,
When you have filed
my
it?
lord, I beg your pardon, my lord.
When you have filed it?
We have filed it, I believe, yesterday. Today, all the defects would be really, I think, have been cleared.
Sunday.
No, I'm sorry. I'm sorry. No, all defects have been cured today itself, my lord. It was before the registrar, all defects have been cured.
Let it come on its stand. We will consider.
Please, my lord.
We'll start.
Delay of 58 days.
What can be done? You did not present yourself when the review was taken up. Review खारिज हो गया सर. So she could not. You served the respondent. Will. Yes. You were not party in repetition. Then you were not represented. Notice was not served or what? Who is the petitioner?
R5. Petitioner is R1. notice, page 44. That learned counsel for
The party will have.
she can take out notice to that learned counsel. States.
5. What about 6 and 7? You take notice to R1 and R6 and 7. Not now. First serve them. Otherwise, same problem. There you were not heard. Here they will not be heard. So let them come. Let them come first.
Only urgency is that we are a second PUC college and the exams are starting to be 22nd of April, madam. Very short duration.
We can have it in the next week if you serve them.
Please, madam, I'll tell you.
To notice to respondent 1, 6 and 7. In addition to the regular mode, the hand notice is given to petitioner counsel, land counsel to serve first, 6th and 7th respondent. Learned area shall accept notice for 2nd, 3rd, 4th, 5th respondent. List for admission next week.
58 days delay is there. 58 days.
In the beginning, right? In view of Supreme Court order such and such, the delay in filing of appeal stand condoned.
Maintainability question is raised. Office objection, including court fee, has not been paid.
The court.
On maintainability. No, sorry. Case is today before us. You will argue after 1 week. It is covered by the full bench judgment of this court. Do whatever you have to argue, you will have to argue just now. No Monday, no Tuesday, nothing. Then huh? In view of the full bench judgment of this court, the writ appeal is not maintainable. That you agree? What left? Nothing remains?
He wants to withdraw.
You want to withdraw? Then why you have filed it? Huh? This intra-court appeal has been filed challenging the order dated such and such, passed in writ petition such and such. Learned counsel for the appellant admits that in view of the full bench judgment of this court, write the name of the parties. ILR 2009, Karnataka 1207. The writ appeal is not maintainable. It is stated at the remarks that he will be permitted to not place the writ appeal. The writ appeal is accordingly dismissed and not present.
Court fee is to be paid.
Hmm?
Court fee is half paid.
Court fee you have not paid. Huh? वो पहले बताना था ना why you were telling afterwards when we feel this.
Certainly, a pay obligation, man. Yes, fine.
Mr. Hanumantappa Ravi order makes a undertaking that he will pay the court fees, deficiency in court fees within during course of this day. During course of the day. We have recorded your undertaking.
Fine.
Bill number 3, here Murali.
The evidence to that. This arrest is also an order. The interim order sought under section 9 of the Arbitration and Conciliation Act. The three facts are like this. The appellants here, sorry,
Just a minute. Yes.
so there are two question about the application itself will not be commercial court. So it's an international commercial arbitration. And therefore, the author comes to the point and go for the application. Because respondent will feed the malicious command. But they are parties to the arbitration agreement to learn which are produced. It is under the Indian Arbitration Act. The first time they took the fee before the court below, not in the Indian. Because they submitted themselves before the court below. They filed their and then they take the plea just because the third respondent is in Mauritius, it's an international arbitration. But the agreement.
Section A, national commercial. One of the parties is like not residing.
Any one of the parties.
Any one of the parties. In the section 9 has to be filed here. That's
Order
the judge.
order set aside. Order set aside.
We'll have of this appeal.
We'll set aside the order.
File section 9 here.
You agree that the order is without jurisdiction. So we will set aside the order. Set aside the order.
That's what the government, we are asking for liberty for filing. I can withdraw this appeal. The decision itself is wrong. We have filed this.
It is better that we set aside the order. Yes, better set aside the order.
This appeal by the applicants in commercial A number 127 of 22 on the file of the LXXXV Additional City Civil Judge Bangalore is directed against the impugned order on IA number 1 filed by the appellants dash applicants under order 39 rules 1 and 2 read with section 151 CPC and section 9 of the Arbitration and Conciliation Act 1996.
Otherwise, it should be section 9 read with order 39.
Section 9 of the Act read with order 39. Interim order. The main commercial A is pending, is it? The main is pending. So you will have to withdraw the main. We'll record your submission that the main is you're going to withdraw, file it here, and this court will decide without being influenced by the findings and observations. Right.
Write only a short order. Both the parties agree. In the inquiry record, as proceedings
Correct.
are without jurisdiction as it relates to international arbitration, and it is not.
Right. Thought if you set aside also, the main will remain.
That they will withdraw.
In
In the undertaking, then.
Right. Record. Learned counsel for the petitioner as well as learned counsel for the learned senior counsel for the respondent jointly submit that having regard to the undisputed fact that the respondent number 3 herein, Messrs. KALYSTA Capital Fund 2 Mauritius is carrying on business, is incorporated in Mauritius, and the dispute between the parties is an international commercial arbitration within the meaning of section 2F of the Arbitration and Conciliation Act 1996, the main petition in commercial AA number 127 of 22, out of which the present appeal arises, would necessarily have to be filed before the commercial division of this court as held in that commercial appeal, that as held in so and so, so and so. Full stop. The joint submission of both sides is placed on record. Full stop. Under these circumstances, full stop. Before that, learned counsel for the petitioner also submits on instructions that the appellant also submits on instructions that the appellant would withdraw commercial AA number 127 of 22, and liberty may be reserved in favor of the appellant to file a fresh application/petition before this court under section 9 of the said Act of 1996. The submission of the learned counsel for the appellant is placed on record. Full stop. Appeal is hereby disposed of, reserving liberty in favor of the appellant to prefer a fresh application/petition under section 9 of the said Act of 1996. Said Act of 1996. That's all, no? Full stop. In the event such an application is filed by the appellant, the same shall be considered in accordance with law without being influenced by the findings and observations recorded in the impugned order. Full stop. Subject to the...
I got to find over nature. Okay, no, this is what happened. Don't say this.
No, you're right. But when somebody reads this,
not the right, we cannot say that we are influenced by the order.
Okay, say this.
Lower
all
court.
rival contentions urged before the commercial court as well as before this court are kept open and no opinion is expressed on the same.
The section 34 petition filed by the respondent here was allowed, and the award which was passed in my favor by the learned arbitrator, he set aside. Lord, the only ground on which the award is set aside is on the ground enumerated under section 34, violation of the principles of natural justice. Lord, violation of principles of natural justice, this concept from time to time, there are various judgments of this honorable court and even the honorable Supreme Court. But the prima facie, while setting aside the award under the principle of natural justice, it should stop the conscience of the court.
What has been done in 34 with respect to the award that has been set aside, and whether any further direction has been issued?
Yes, further direction is issued without I'm imposed with the cost and I'm given the liberty to invoke arbitration clause consideration.
Matter has not been remanded.
No, my lord, matter is not remanded. Lord,
What is your contention that principles of natural justice are not applicable?
please, Lord.
What is your contention?
Lord, my submission is this, Lord. Ultimately, whatever the proceedings have happened before the learned arbitrator, Lord, the parties were duly given advance notice by the arbitration center, where this
To begin the arbitration again. Let me read.
34, either dismiss or allow and arbitrate again. Usually. Heard learned counsel for the petitioner, appellant, and peruse the material on record. Full stop. In addition to reiterating the various so and so, learned counsel for the appellant submits that the impugned judgment and order passed by the commercial court is contrary to the provisions by which the commercial court set aside the well-reasoned and proper arbitral award passed in favor of the appellant is contrary to the parameters of Section 34 of the Arbitration and Conciliation Act 1996, and consequently the same deserves to be set aside. Submission of learned counsel for the appellant is placed on record. Issue emergent notice to respondent. List after service of notice. Meanwhile, the impugned judgment. Otherwise, they will start arbitration.
Who will start? He is
No,
the
respondent.
claimant.
filed this IA, Lord, IA for temporary injunction I have filed because of this reason, Lord. I had also filed.
Let them appear. Let them appear. What interim relief can be granted in this?
Please, Lord, I enjoyed the benefit of this temporary injunction right from the date of the arbitration proceedings till the property was brought for auction. Lord, there was only one property.
You serve them hand notice. Without hearing, we will not do anything.
I may be permitted to take notice on the
Appellant also permitted to take out hand summons and serve the learned counsel for the respondent who appeared before the commercial court. Date.
Hand notice कर दो.
I appear for the
Given a date.
appellant's counsel on 21st, my lord's directed notice. In so far as R2, 4, and 8 are concerned, my lords, I think keystone partners are present there. They may be directed to take notice. And in respect of R5, my lords, learned counsel who appeared in the trial court before is the same person who appeared for R1 also. He is there in the court. Completion of service, if it is recorded, my lords, a short date may be given where the matter may be posted for admission.
Respondent number 5. Legal file. Right. Learned counsel appearing on behalf of respondents 1, 3, 6, 7, and 9 accepts notice on behalf of respondent number 5 also. Full stop. Shri Pradeep Nayak on behalf of Mrs. Keystone Partners accepts notice on behalf of respondent 2, 4, and 8.
And 8.
You just need to print the name of the learned counsel. Statement of objections to be filed by next date of hearing. Not received.
उसी के लिए लगा ही है. सर्विस से पहले नोटिस दिया था.
Sir, Rajgopal sir.
Yes, ma'am.
Before vacation, after vacation date, when do you want?
Any time convenient to the court, my lords. I am in the hands of my lords. Whenever my lords say.
After vacation. List date after vacation. 27/5. Sir.
Grateful.
क्योंकि अपील में अपील एडमिट कर लो, एडमिशन उसमें उसको सुनने की जरूरत है तो कोर्ट का
Correct. Admit.
एडमिट सेकंड मैटर
Connected.
some interim order in the connected matter. मेंटेनेबिलिटी का भी क्वेश्चन है. करना क्या है? What is to be done today?
Now, this arbitration suit under section 34, it should have been a commercial arbitration suit. Right.
कोर्ट एक्ट के पहले का होगा ना.
No, whether the trial courts, that is the principal district judge Davangere, whether the judgment, the order passed by it arises out of a commercial dispute or not. This should have been no, this should have been decided by the commercial court. Correct. After the act came into force, question is whether this suit, arbitration suit, was maintainable before the PDJ Davangere or should have been tried with a designated commercial court by numbering it as a commercial AS or not. If it has not been done, it becomes without jurisdiction. That's what the office has said.
Officer said otherwise.
Okay. I didn't see.
Yeah. It has said it is maintainable. वही तो गलत है. Set aside judgment.
Commercial court act.
Setting aside.
Should this have been treated like a commercial AS? Not the appeal. The commercial AS should have been treated as a.
After coming into force of this Commercial Court Act, all those suits relating to the arbitration cases, Arbitration Act, they were required to be transferred to commercial courts.
So they were not transferred. This was not transferred.
If it is tried by some other court than the commercial court, then it is without jurisdiction. Oh, when your case was decided, at that time, whether the courts were constituted or not.
It was this constituted.
Report from the office itself. Yeah.
We'll have to set it aside and send it back.
Office has not taken this objection. Office got objection.
Whatever office has said, either way it doesn't, for the purpose of designation. PDJ only. That may not matter. In Davangere, if the principal district judge was itself designated as a commercial court, then merely because he doesn't call it as commercial AS, will it make a difference if he is a designated court? The designation, nomenclature. That's it.
But the thing is, he is decided as a PDJ. Not as a
No,
commercial.
but if he was the commercial court,
So then the case would have been transferred, renumbered as commercial.
no, it would have remained with him, but renumbered as commercial AS.
तो वो हुआ नहीं है.
Hyper-technical.
It is just by chance that he is the same person.
Nomenclatures, if nomenclature change होगा.
कहीं ये raised भी नहीं हुआ, ये बड़ा ताज्जुब है. This issue has not been raised here.
Correct. Now, why is it that this issue never came up for consideration all these days?
Let us be clear on the facts first, whether this issue of maintainability was raised or not. Which order?
No, there are three notifications in that Sridhar Prabhu's matter. They are produced. First notification, it was only Bangalore and Bellary. Then they said separate courts all over Karnataka. Then they deleted corrigendum. Which is your matter, Sridhar Prabhu? Srinivas. Just to test this jurisdiction. Serial number? Next matter is serial number 8. Serial number 8, buddy. To test this three. Only the notifications we want.
देखो मेंटेनेबिलिटी पे कुछ है रिपोर्ट ऑफिस का.
The first one is dated 196. 31/7/2018. The first is 31/7. Bangalore and Bellary. The 9/10/2019. 9/10/19. Allah? No, for us this is good enough because this suit is of the year 2018. For our purpose, that is then 9/10/2019. Davangere is PDJ. That's right. Thank you. It should have gone to, it should have been renumbered. 6. Same judge, but renumbered as commercial AS. Correct, sir. Correct, sir. We saw it, sir. That's what. 2018, 3 courts. When you filed the suit, it was only Bangalore and Bellary. When he filed the suit, is it? You filed, Allah? They filed. When you filed the suit, that is arbitration suit, There are only 3 courts, Bangalore and Bellary. During the pendency of the suit in 19, Davangere PTJ also was designated, right, as a commercial court. The only thing what happened was the nomenclature of the suit, instead of commercial AS, it continued as AS. Court has jurisdiction.
One more problem may arise here, apart from what my lords have stated. This, in view of the hours of this 2019 notification, in 2018, the OS ought to have been filed before the Ballari court. If the matter were to be really treated as a commercial court matter. Whether Davanagare's principal district judge is declared in 2019, the hours of that. Earlier, Davanagere
Decided in 21, no?
court matters were that of a Ballari. Not at Davanagere.
Then it would have been transferred. But it is so initially when it was filed, it is filed in a court without jurisdiction.
Yes.
But subsequently court gets jurisdiction. I don't think it's an incurable defect.
I just brought it to my last one.
At the time when it was decided,
At the time of it being decided.
they had the jurisdiction. No?
Correct.
At the time of decision, that court was granted.
That takes care of, since it is not shown as commercial AS, here it is not come as commercial appeal. So we can hear on merits then, there is no difficulty. This is a problem. It is not commercial AS, it can't be treated as commercial appeal. So that should have been first done. So this has to technically remain a MFA, but we'll have to say that since there is a mistake, we take it up. Nomenclature doesn't not affecting jurisdiction.
It's important. Order.
The mistake appears to be made on appears to have
After this
crept in
order, whether
because
we-
of your submission. That the office has to treat it as a commercial appeal.
Submission by the office.
There was no need. How does it matter? It's out after an appeal, right? It's called commercial appeal. It could not have been called a commercial appeal because it didn't arise out of a commercial AS.
Yeah, this-
Nomenclature wise.
Decided as AS.
As AS, it has
Therefore,
to
it has to be
be
a-
MF.
not as commercial.
and section 99 CTC procedural technicality, but constituting commercial appellate division.
Okay. What do you mean?
We will take it up on merits whenever you people are ready. I'm hearing.
So, I don't know.
I take only 5 minutes of your order. Not take more time. Because it's 2008. They say cash is being 2008, 75 lakhs. No books are accounts are produced. No documents. You have to hear us. April 1 date. 20th April.
ये थोड़ी ना
Produce everything.
admit development.
Respondent is pressing for urgency. We leave it at this stage and simply real estate. We'll see on that day. We'll have to hear it.
There was also not a central empowered committee. There were two entities.
Right.
The central empowered committee recommended sale of subject serial number 2. That document number 2 will not take 16 of the agreement. But we have filed not a convenience compilation and we have not one. So they have not one. Therefore, not both have been put in that list of names. What which document you are saying you are saying
What was the dispute? Time लगेगा.
बहुत time लगेगा.
See in the matter today. Because what we
Respond.
find, it will take time. We are already at 3:30. Some it will take time because have we done some other?
Some of it. Next Monday. Next Monday. 4th of April. Due to paucity of time, adjourned to 4th of April. Interim order granted earlier is extended till next date of hearing.
Crystal dates इधर उधर जाएगा.
4th.
Misplaced ना हो जाए.
6th. 6th. 6th of April. 7. The only point is whether you have forfeited your right. That's the only point, actually. Other, I don't know. There could be.
That is one aspect, whether they have filed that application under section 16 not filed, and whether they have forfeited their right. Your right. Not me forfeiting, they have forfeited. Yeah, but those are the things.
All 7. Return of plaint, Ramnagar in Bangalore. Any consensus? New point. Before the new point, we asked both of you whether we asked you whether you want to go to Ramnagar, whether we asked him whether he wants to continue in. No. What my lord, we had indicated last time was we'll set aside the impugned order and send it back for reconsideration by treating this issue as preliminary issue. That was not what we had indicated. We adjourned it only to find out whether either of you are ready to continue.
Yes, I was not till recently. I had the thanks to my learned senior team. Just after this identity, I just not persuade your lordships, even the evidence cannot be required. This one point your lordships may consider.
Right.
Section 91 of the Evidence Act.
No, why did you talk to senior? Actually, no, you're supposed to talk to the
You
party.
saw me arguing this interesting case. Mr. Pramod Nair said, Lord, I have this point, why don't you? And so
Right.
I'm really grateful to him. This never occurred to me. He stopped the car, made me sit and read this, gave me material, and he's not.
All right. Oh, Pramod. Right. Okay.
All credit fee, everything should go to him.
Right. All right.
Section 91 says not the evidence of the contract, grants, and other dispositions of property reduced to the form of document.
Evidence Act.
Supposition just occurred to me, so I could have carried the books and assisted. Terms of contract or a grant or any other disposition of the property have been reduced to a form of document. In all cases in which any matter required by law to be reduced to the form of a document, no evidence shall be given in proof of the terms of the contract. Reduced to the form of document, no evidence shall be given in the proof of the contract or any other disposition of property or any other matter except the document itself or secondary evidence of its content in cases where the secondary evidence is admissible under the process here before. Respective submission is clause. The contract, not just the contract, there is an addendum also executed. Page 53 is the contract. And Lordships will see that there is also an addendum executed. Both are valid. One time, what I can understand, there can be a mistake. Lordships will see page 53, value, clearly says value. And Lordships will see that there is an addendum executed on 82, page 82. That is also value. 2019. So what if somebody, even if let us presume that is a mistake, a mutual mistake, then what?
Sridhar Prabhu.
Yes.
The argument was
Yes.
part of a cause of action arose at Bangalore because the agreement says it is executed at Bangalore.
Yes.
However, in reality, it was not executed at Bangalore.
Yes. Now, I am saying, if it was not executed in Bangalore, there is no reason why.
No. If there is a dispute with regard to whether it was executed at Bangalore or not, we indicated, then we'll relegate you back.
Yes.
Both of you adduce evidence and then come back.
I am answering that point. One is evidence cannot be used. One, section 26 of the specific relief act says that there is, if at all, if there is a mistake in any contract, you have to file a rectification suit. If it's not, instead of 1 lakh, I write 1 crore, vice versa. this section 26 specifically says that a party must execute a law for rectification.
No, now are you saying that in reality, if the parties instead of staying here decide to go to Ramnagar and execute it there for whatever reason, then notwithstanding the actual execution having taken place at Ramnagar, for the purpose of legal execution, we have to presume it is at Bangalore? Are you saying that?
Then what is agreement?
No, that's what you're trying to say.
Document itself.
That's what she's Are you saying document says Bangalore, but in reality it is at
Not in reality.
one second, as contended by them, it is at Ramnagar. However, though it might have been executed at Ramnagar, because it says Bangalore, you can't adduce oral evidence or any other evidence contrary to the terms of the document in terms of 91 or 92, and therefore the document is the end of it, and it's not open for them to show that the document was not executed at Bangalore. Even assuming in reality it is there.
That is one proposition.
Ah.
Secondly, section 26 says that in
Right.
such an eventuality,
Right.
you have to execute a
Section 26 is only a right to file a suit for rectification. Section 26 does not speak about a duty cast upon a party to get it executed. It is a right to file a suit. So 26 will not apply.
That clause is not exercised.
26 will not apply. 26 will not apply. But it is open for them. Is it open for them to take up such a contention or not? According to you, they cannot take up the contention because of 91 and 92. According to them, they are entitled to take up the contention. Therefore, we will set it aside and send it back. Isn't it?
The issue is, and no, if there is a bar, statutory bar,
Where is the bar?
that 91.
Let's see if there is a bar. 94. Where is the bar in 91? In proof.
91.
Yes, no evidence shall be given in proof of the terms.
Yes.
Right. They want to give evidence to contradict. 92 says no oral evidence you can give to contradict. They are producing emails. Alba? See, 91 says exclusion of oral by documentary evidence. There are exceptions also. Both have exceptions. 91 has exceptions. 92 has exceptions. 91 says you can prove a document subject to exceptions only by the document. 92 says you can't adduce oral evidence except by under certain circumstances.
Yes. Now,
Therefore,
what?
91 are then settled. 91 is the terms of the grant. They won't
Correct.
for you to make it in terms.
That's right.
And go to law, this is called Federal rule of law. Federal rule.
Right.
Then law that
No, let the trial court decide that. No. See, they have so far as concurrent jurisdiction is concerned, I don't think we need to labor on this anymore.
that also, but I will not totally divorce that. I leave it to your lordship if your lordship want to keep it.
Let it go back. Let it go back. We'll send it back.
But this on the notification law, when they have already taken a view. So I will again be urging the same point, Lord, that is what if your lordship.
That I think not need not get
Yeah. King.
notification is quite settled.
Yeah, that Lord, I leave it to your lordship. Let it be settled this way or that way, Lord. Because again, only on these 91, 92 and there was principles I have. Because this way I understand, Lord, what are the implications.
So there is no bar. 91 is not a bar. 92 is not a bar. They want to produce, it's not a bar. Where is the bar?
So, Adil, that Lord is a separate issue. As far as those two issues that I urged before your lordship, I can urge before them, even if your lordship will
Make one
I'm
submission.
only saying on this
When they
notification.
produce the emails along with their application, they were asked to file their objection, but they did not object to those views, they did not dispute those
Now,
views.
one
The
thing.
matter was argued also not when we pointed out. In fact, the Lordship sees the representatives, they did not dispute those views, they did not even dispute the fact it was executed at Ramnagar. Even in the appeal report, the Lordship sees challenging the orders of the lower court.
Srinivas, it may not be as straightforward as that for this reason. What is cause of action? Not defined, as you know. We've been arguing this from a bundle of facts, all that entire theory.
Not, the Lordship said.
No.
We need to point out that the execution actually took
Understood.
place there.
They are not required. What I'm no, not required because the arbitration clause says Bangalore. What is that?
Arbitration clause is Bangalore. That is not dispute clause. According to them, it's the dispute clause. I will also confirm it.
Dispute.
First.
No, but isn't there an arbitration agreement? Last time we read out.
There's a word arbitration, but there's no arbitration clause.
There's no valid and binding.
Arbitration agreement section 9. The section 9 quotes that there's no arbitration agreement, therefore
Right.
section 9
No,
cannot be done.
what we were trying to think, what we thought was that the cause of action to file the suit is relatable to this agreement. Okay? The agreement consists of one party who is at Bangalore. So you have to connect appellant, that party who is not a party to the suit, and the agreement. If you connect all three and the cause of action arises out of a document to which then court at Bangalore will have jurisdiction.
Page 75
No, we are not on page 75. We are on the fact that the non-party to the suit is a party to the agreement and he is at Bangalore. Your cause of action to claim any right under that agreement in relation to a document of which one of the parties at Bangalore will arise at Bangalore. Arthur. Right. That's probably.
Yes. If we connect the dots, because one of the party who is a trader who has to purchase the power and sell is situated in Bangalore. So Bangalore
And your suit is based on that document in which one party is at Bangalore, then you get a cause of action at Bangalore.
he will not connected us. He is the one who is
That's,
situated in
we'll send it back. We'll send it back. But what ground do we?
Bangalore.
Why should we? Or issue of law. Mixed question of law, we can't say.
But we need one submission. But so far, order 10 is concerned, we also see the context of order 7 to 11. Supreme Court has not order 10 the examination of parties court can do at a preliminary stage to find out what even maintainability or rejection. That is something not just below. Not the under order 10, the court puts an exam, not parties.
And
All even questions of fact. Therefore, if it finds on examination itself.
Basis of
But
evidence.
because that they say what the article said, since we produced it along with an application. But
The procedure under order 10, you want us to direct not as a preliminary issue. Order 10, how does the court pronounce on the issue regarding territorial jurisdiction?
The question not the issue of as to where it is executed. But if that is not
On the broader issue of.
then it becomes a question of law, because the Lordship sees so far as that is concerned, then not the facts are not, he does not dispute the execution in Ramnagar, which what I had placed along with names. But since Lordship
He is disputing it.
but if he is not, he could be examined not under order 10. Lordship sees not that.
And then what?
Then what?
And then what?
Then what?
That
One second, let us see that.
The issue of what law in fact lies in the same suit.
Jurisdiction of the court. That's it.
CPC in fact is not applicable in arbitration. We cannot.
This is a suit. This is not arbitration. The suit only. commercial OS. This appeal by the please take a seat. This appeal by the plaintiff in commercial OS number 693 of 21 is directed against the impugned judgment and impugned order dated 21/12/2021 passed in commercial OS 693 of 21 by the LXXXVII additional city civil judge bracket exclusive dedicated commercial court Bangalore, whereby the commercial court returned the plaint filed by the appellant plaintiff by coming to the conclusion that the suit is barred by on account of lack/want of territorial jurisdiction on the part of the commercial court. Next, heard learned counsel for the appellant and learned senior counsel for the respondents. Who all? Respondents? Which respondents? 1 and 2. 3 also? For disposal. Or you let them file wakalat on behalf of 3 also.
25.
Right. For the respondents and peruse the material on record. A perusal of the material on record, you filed 7 Rule 10, is it?
Yes.
Material on record indicates that the appellant plaintiff instituted the aforesaid suit against the respondent. Where is the prayer? Page 135. 135. Aforesaid suit against the respondent's defendants for declaration and other reliefs. Declaration, other reliefs. Full stop. In addition to
termination notice.
declaration that the termination notice dated 7/7/21 issued by respondent number 2 dash defendant number 2 as was illegal, void ab initio and not binding on the plaintiff and for other and for other reliefs. Full stop. The said suit was contested by the said suit having been contested by the respondents defendants, comma the respondents the said suit. In addition to contesting the said suit by filing the written statement, comma, right, full stop. The respondents who contested the suit filed the application under Order 7 Rule 10 CPC to seeking return of the plaint on the ground that the commercial court did not have territorial jurisdiction to adjudicate upon the issues involved in the suit. Full stop. The appellant dash plaintiff having opposed the said application, comma, the trial court proceeded to pass the impugned order on jurisdiction and authority to represent the case by the defendants by passing the impugned order, allowing the application, thereby directing return of the plaint to be presented before the jurisdictional court, proper court having territorial jurisdiction. Full stop. In addition, next para. In addition to reiterating the various contentions urged in the appeal, comma, learned counsel for the appellant submits that the trial court committed an error. The commercial court committed an error in coming to the conclusion that it did not have territorial jurisdiction to adjudicate upon the suit. Full stop. In this context, learned counsel invited our attention to the solar power purchase agreement dated 27/11/17 in order to point out that the said agreement having been executed at Bangalore and including Messrs. Atria Energy Services Private Limited as one of the parties which had its office at Bangalore, comma, the commercial court at Bangalore had territorial jurisdiction to adjudicate upon the suit, and consequently the impugned order passed by the commercial court coming to the conclusion that it did not have territorial jurisdiction to adjudicate upon the suit was incorrect, was erroneous, and deserves to be quashed. Full stop. It is also submitted that the impugned order passed by the commercial court suffers from other illegalities and infirmities, resulting in erroneous conclusion and warranting interference by this court in the present appeal. Full stop. Per contra, learned senior counsel for the respondents, per contra munche. It is also pointed out, it was also contended that in view of the specific bar contained in sections 91 and 92 of the Evidence Act, it was impermissible to adduce either oral or documentary evidence to either to prove or disprove the contents of the undisputed solar power purchase agreement dated 27/11/17, which categorically states that the agreement was executed at Bangalore, and as such the commercial court had territorial jurisdiction to adjudicate upon the suit. Full stop. Next para. Per contra, learned senior counsel for the respondents submits that notwithstanding the fact that the agreement recites that it was executed at Bangalore, in reality the agreement was executed at Ramanagar, beyond the Ramnagar and Hyderabad, beyond the territorial jurisdiction. Exact sign signed here one party, right? At Ramnagar and Hyderabad, and beyond the territorial jurisdiction of the commercial court at Bangalore, and the commercial court came to the correct conclusion that it did not have territorial jurisdiction to adjudicate upon the suit. It was also pointed out. Next, it was also pointed out that the question, the factum of execution of the agreement by the parties at Ramnagar and Hyderabad was not disputed by the appellant before the trial court, and it was an admitted fact, and as such, no portion / part of the cause of action had arisen in Bangalore so as to clothe the commercial court at Bangalore with territorial jurisdiction to adjudicate upon the suit. It is also contended that in view of the well-settled principle of law, that for the purpose of considering an application under Order 7, Rule 10 CPC, it is only the plain averments that can be looked into. It was incumbent upon the appellant to assert in the plaint that he had executed, that the agreement was executed at Bangalore, and in the absence of it is incumbent upon the appellant to assert in the plaint itself that a part / portion of the cause of action had arisen at Bangalore, and in the absence of such assertion, which was conspicuously absent in the plaint, the trial court was fully justified in coming to the correct conclusion that the commercial court at Bangalore did not have territorial jurisdiction to adjudicate upon the suit. It was therefore submitted that the impugned order passed by the trial court returning the plaint was perfectly just and proper, and the impugned order does not warrant interference by this court in the present appeal. Full stop. After having heard the learned counsel for the appellant and learned senior counsel for the respondents, a perusal of the material on record discloses that the issue with regard to whether cause of action for the suit arose in Bangalore or at Ramnagar is essentially a mixed question of fact and law, which would have to be adjudicated as an issue, as a preliminary issue, along with other issues as contemplated under Order 14, Rule 2. One second. That's right. That's 1 second. 2A. Order 14, Rule 2, small a, CPC, after giving sufficient. Order 14, Rule 2, Clause 2, Clause A, which would necessarily involve giving an opportunity to both sides to adduce oral and documentary evidence in support of their respective claims. Full stop. In view of the material on record, which indicates that there exists a serious dispute with regard to the territorial jurisdiction of the trial of the commercial court to adjudicate upon the suit, necessarily involving recording of both oral and documentary evidence, we are of the considered opinion that the impugned order passed by the trial court, commercial court, deserves to be set aside, and the trial commercial court and the matter remitted back to the commercial court for reconsideration of the issue regarding territorial jurisdiction afresh, as a preliminary issue before proceeding further in the matter, and by leaving all contentions open. Full stop.
Trial court shall consider.
Choose to do so. Next, liberty is also reserved in favor of the appellant dash plaintiff. Liberty is also reserved in favor of the parties to adduce both oral and documentary evidence. In rejoinder ಆಗ್ತೀರಾ? All rival contentions will keep open. That's why we record it.
If your lordship permit, then it will be like saying that I cannot urge this point. If it is permissible not to law, then it is something to be argued, not correct.
That we leave it to the court to
That
decide.
is what I am playing. If
We
your
will not.
lordship
We will not say anything about 91, 92.
Right.
That is, let that be
What did we write?
court to decide whether it is permissible or not.
Liberty is reserved in favor of the parties. Liberty is liberty is reserved in favor of the parties to adduce both oral and documentary evidence, if permissible in law, in support of their respective claims. All rival contentions between the parties, including the contentions urged above, are kept open to be decided by the commercial court.
Including the contention that no oral evidence can be used. That's what I am saying. That is not.
And their
That is not. So observe that I did not say
above.
whether my contention to that effect was.
All rival contentions urged by the learned counsel for the appellant as well as the learned senior counsel for the respondents on all aspects of the matter are kept open. Sir, why do you trouble the government and...
No, that will be in the interest of association of advocates.
No, we might as well withdraw that notification, no? And put everything in the object of constitution.
That was my ground, prime ground in appeal.
That was the only ground that
correct. So when I have that ground,
Not learned friend, somebody else.
that was the only ground which I understood. Therefore, I was
that's what I did not.
Right. All rival contents kept open, no opinion is expressed on the same. All rival contentions. Right. MFA fees ಹಾಕಿರ್ತೀರಾ?
That same fee is to be paid. That's a huge commercial problem. Same fee that I paid the commercial court is paid before the lordship. Lordship may allow not that because it was disposed of in my favor.
So that provision 64, court fees suits valuation. In view of setting aside of the impugned order and remanding the matter back to the commercial court, the appellant would be, the registry is directed to refund the court fee paid on the memorandum of appeal in terms of section 64. 64 of the Karnataka Court Fees and Suits Valuation Act. Right.
8 July 2021. This matter laws, as per the direction of this matter, what are the laws? Inquiry regarding the school being the fire zone laws. That inquiry is going on. I see a short accommodation laws. I file the report of the inquiry and file.
We are just seeing the photos.
8 July 8 July. Just material muscle to like 40 acres.
Fan closed.
8 July.
State government. They have said they have removed the encroachment.
Page 41. The 8th July report. Memo of reporting complaint of number of the number 21.
Right.
Then they enclose a state. Then the various encroachments are not there. Thereafter, subsequent of finding with all these things. Another report was filed on 17th March.
You filed one more survey report.
So there, by look of that, part of the most of the what is submitted encroachments have been removed. But the extent as far as the fifth transport college is concerned, the main event of the petition is 28 guntas, but they are saying it's 6 guntas. Then I produced the other sketch by other memo which I filed. Now they have to recheck that aspect whether it is 28 guntas or 6 guntas. They have to submit it.
Now, what about these people? They are you are the encroacher, huh?
College.
We have not any piece of land, my lord. Even the survey report says that. When you can see the survey report, my lord, they say that 6 quintals of land. Kali Jaga only mentioned, ma'am. They are shown it as the vacant possession. How can we ensure the vacant possession? We are not ensured any piece of land, my lord. Even I have filed my affidavit saying that they are not ensured any land.
ಇವಾಗ latest full pakka proper survey report taking into account all earlier will you file? No, will you file it then? File it, look, take into account that college. They are talking about a temple, so we want a complete report of everything and then file a fresh one. Right.
In compliance of that, my lords, we have issued notice to the fifth respondent that they have given reply. Matter is set out tomorrow.
That is one college. What about the impleading applicants? They also say they have a temple and a college.
So they want to assist report, let them remain.
That's all, huh?
That text include it is mine, and that my lords, notice has been given. They have used the reply. Matters to be heard and disposed of. 2 weeks time, lords.
What are your instructions on R5?
Yes.
What are your instructions on R5?
R5 is the person. College. They have.
According to them, they have not encroached. What are your instructions?
Lords, just now I have received that they have filed the reply.
That's what. Did you have? What do they say in that? Okay, whatever they say in their reply.
They say that they have not encroached upon.
What are your
They have
instructions?
produced that tomorrow it is set out for hearing. It will be heard and an order will be passed.
All right.
I have filed my objection, my lord. They have given the notice to me for the encroachment. I have filed my objection.
At request of learned AGA, June 1st week.
But this record also filed the
Latest status report.
later question. And once it is called, they have to send it to you.
Let them complete the inquiry. Let them furnish a report and hand it over. Latest status report will be filed by the next date of hearing. No, as interveners, you can be there. We won't do anything.
Let the applicant remain.
IA 1 of 22 will be heard, is directed to be heard along with the main petition. You are only assisting, Alva. Ah. Right.
The total report is contrary to the earlier survey and the.
Now, according to you, is there encroachment or no encroachment?
According to me, I have temple is being situated in survey number 1, not in survey number 14, which is claimed to be a lake.
Right.
Now that may not, as per the earlier report, now that may not the present report, what has been made contrary to the earlier survey report, that I have been encroached in survey number 14. I am not at all in 14.
Okay, Mr. Shori, can you permit them to participate in the inquiry also? The inquiry, so that you get a, it binds them also then. Whatever report you produce would bind them, isn't it?
Yeah, that was only confined to issue notice to them. That was only.
All right, that's why we asked you. If you say yes, right, learned AGA on instruction submits that inquiry have been, that pursuant to order dated 11/11/21 passed by this court, comma, inquiry has been initiated against respondent number 5 and this please write it down in so and so, and the matter is set down for inquiry tomorrow. Date, tomorrow's date. So submission of learned AGA is placed on record. Learned counsel for the impleading applicants seeks permission to participate in the said inquiry proceedings also on the ground that the said inquiry would affect their right. Full stop. A submission of learned counsel for the impleading applicant is placed on record. The impleading applicants are also permitted to participate in the said inquiry and submit their pleadings, documents, etc. A report of the inquiry as well as latest status report to be submitted to this court by the next date of hearing. Realist on date. LAQ, LAN number, inquiry number.
My lord, I appear for the petitioner, my lord. The respondent number 9, my lord, was directed to file objections.
Nine responded to file statement of
Correct. Let us say something. At request of learned counsel for respondent number 9-KIDB, released during first week of June. No urgency. Tomorrow new Upulokayakta we are getting. So we'll adjourn this. We'll simply adjourn it. Whatever has to be done, you people do. After vacation one day.
Don't give the date. A lot of dates have been given.
List after summer vacation. Latest status report, if any, to be filed by next date of hearing.
My lords, I appear for the petitioner. My lords, in this matter, on the last date, the objections of the respondent to our application for amendment was to have been filed.
I appear for respondent number. The objections are ready. I request a 1 week accommodation. We have circulated it. We'll file it within a week, my lord.
Then, my lords, would my lords be kind enough to have it either on 4th or 15th April, sometime in the before vacations, if my lords are willing, my lords. Ultimately, the amendment can be heard.
At request of learned counsel for respondent number 1 to file objections to IA 1 of 22. List after one date. Don't give a date. June.
Early June, my lords. First week of June, my lords.
Yes, month of June.
Yes,
Right.
Grateful.
Adjourned on the
Supreme Court में ना
adjourned on the request made on behalf of counsel for the petitioner. Just again.
In the second matter, I represent third respondent, my lord.
My lord, in the main matter, my lord, I represent the Animal Welfare Board, my lord. Respondent number 6.
What is the matter?
I am
Lord,
the,
Death of monkeys.
I am the petitioner in the second matter, my lord.
Status report. The connected matter. Is it?
During the pendency of the second petition, my lord, certain monkeys were poisoned in Hassan. That led to initiation of the suo motu proceedings by the Assam court. And the first writ petition is the suo motu proceedings that is initiated.
You don't have first petition. ಹಾಕಿದ್ದಾರೆ ಅಂತ. You'll have to come out with some kind of a action plan with regard to protecting monkeys all over Karnataka. The second petition. Has it been constituted? Right. No, has the government approved this proposal? Learned AGA on instruction submits that the respondents, that the state, in consultation with BBMP, in consultation with the BBMP, is in the process of taking necessary steps to safeguard and protect monkeys, and seeks time in this regard. Released during June 2022.
26/7/2021 was also the same submission that was made. It almost more than a year, my lord. There's a detailed order on 26/7/2021 by the Assam.
Radhanandan, we are talking about the monkeys in the entire state of Karnataka.
My writ petition is limited to the city of Bangalore because I had only
But the
brought
PIL, we are
during pendency of the first petition, certain monkeys were poisoned in the Hassan district. Therefore, the so much proceedings were initiated.
That's right. But in the
Yes, my lord.
PIL, we are concerned with the safety of monkeys all across Karnataka.
Correct, my lord.
My lord, in so far as Bangalore is concerned, the BBMP has filed its status report on 1st September 2021 after conducting joint meeting with the state officers, my lord.
Some government order, some executive order, a detailed order with all guidelines, precautions, everything. If you place it on record, we can look at it. Right.
Public.
Date, my lord.
It will come in June.
Possible to grant.
Yes.
Your financial tool may kindly be seen.
R2.
R2. Page 14 may kindly be seen here. Lands have been identified in each district. The money is also being allotted. 17.3 lot, 2023 detailed as of that day. Then lots further lots budgetary allocation is made in this budget also, and the intention is to increase these Gaushalas from 30 to 100. Lands have been identified.
It is only on paper.
How many Gaushalas have you built?
Nothing.
No, this in the year government land voluntarily handed over. When was it handed over? When was it handed over? You have to file a proper status report with regard to handing over, with regard to the status of construction development of each one of the Gaushalas you have identified in this
Establishment of Gaushalas.
How many Gaushalas are actually constructed? Not in one. So land is given, money is given, no Gaushala.
No Gaushala.
Not even given, identified. Identified. Land is identified on paper, like my
That is
lord
what
said.
we say. It is only on paper.
Paper.
You have identified the land. You have allocated the money. That is all. But in actual, it is nothing. Neither there is any Gaushala established, nor any efforts are being made to establish the Gaushala. You have to file the status report as to how many Gaushalas have been established on these identified lands. We are not satisfied with this.
Pursuant to the order dated last date of hearing so and so, the state government has filed a compliance affidavit along with documents. Full stop. Learned AGA submits that lands have been identified for the purpose of establishing Gaushalas
In
each district in Karnataka, the state of Karnataka, and
money have been allocated.
money has been allocated in this regard. Full stop. However, no material is placed to show whether the land is whether any Gaushala has been established in any of the district as stated in the said documents. Full stop. We are not satisfied with the details given either in the compliance affidavit or the documents with regard to steps being taken by the state government to establish Gaushalas. Full stop. Under these circumstances,
We direct the state government to take appropriate steps for the establishment of Gaushala on these identified lands in a time-bound manner, and the status report is certified by the nation.
under these circumstances, we direct the state government to take appropriate steps to establish Gaushalas in the lands identified in the document produced as Annexure R2 to the compliance affidavit dated 25/3/22 and file a status report in this regard by the next date of hearing. First week of June on date.
Permission for application, right?
What is the appointed expert committee on not complaint of the University of Agricultural Science? You know about 9, where in 2 of them there are trees. Whether or not those trees should be retained, whether they should be transplanted, and whether or not they should be cut. That report is before your lordship. Pursuant thereto, the key officer has filed a office number saying that discrete trees can be removed, discrete trees have to be transported.
We'll fix a date. When is the matter listed? Next week? One week time. And counsel for the petitioner. They file the objection to the applications. This give the numbers of these applications within 1 week. Give a date after 1 week. One and two. On IA 1 and 2 filed by respondent. The the petitioner may also file their objection to IA 3, 4, 5, 6 by the petitioners within 1 week. Give a date. 6th April. Oh, these are first IA 1 and 2. They have been filed by the respondent, on which you will file the objection, and 3, 4, 5, and 6 by the petitioner, to which respondent will file the objection. This is what we have said. Give it it.
There is
Part
one
on IA 1 of 2022. Give it it.
suggestion that copy of writ petition is to be served on government advocate.
You serve the copy to the AGA. No, with no name. Serve the copy. Petitioner counsel undertakes to serve the copy of writ petition to landed AGA. Correspondence.